Hi everyone, Elvis Abenga here. Welcome to this episode of Diaries and Reflections of a Kenyan Lawyer. Today we are going to make a discussion and have a conversation with regards to the criminal process in Kenya. A lot of people, when they get arrested, they do not know what to expect. It's a moment of anxiety. It's because you feel like you're treading in some waters that you're not very familiar with. The purpose of this video is to give you an outline of the criminal process in Kenya, from arrest to either conviction and or acquittal in that sense, so that if you ever be unfortunate to get caught up in such, you can be able to know what you should be able to expect out of it. First and foremost, if ever you get arrested, do not resist arrest. Cooperate with the police as much as you possibly can, because it's only when you do that that you are able to prevent or limit the occurrence of injury to yourself. The police are not supposed to beat you up or physically assault you if you have not resisted arrest. If you ever face a situation of police brutality, you need to make a report to the Independent Police Oversight Authority, and they will take up the matter and have you get the redress that you need. But that notwithstanding, we'll talk about arrests in another video. Today we're just talking about a rough overview of the criminal process in Kenya. So you're arrested, you'll be taken to the police station, and once you're in the police station, they will take down your details, book you in an occurrence book, which is called the OB normally. It's a very big book, and it's only one in the police station. Taking your details, they will take in your fingerprints and biometrics, and then maybe book you in the cells. I would want to say that under Article 49 of the Constitution of Kenya, as well as Section 123 of the Criminal Procedure Code, you have a right to bail or bond. I will differentiate between bail and bond. Bail is money that is paid to the court or to the police to secure your presentation in court. So what happens once you've paid this amount of money? You are allowed to walk out. A bond is an agreement that is entered between you and the court or the police that you will attend court on a specific day. Now, at that point of arrest, you're in the police station, and so the bond that you will be given is called a police bond, and that is only given by the OCS, or the officer commanding the station, not any other police officer. Some policemen take advantage of unsuspecting members of public to extort money from them in the name of giving them bond. Always make sure that the person you're dealing with, or if it's a relative coming in, is only dealing with the officer commanding the police station. That is the only officer who's allowed to give you bail or bond. After that is done, you are supposed to be presented within 24 hours in a court of law. But if it's on a weekend, then it will have to go to the next working day. Then after that is done, you're presented in court, charges are drafted, the prosecution presents what is called a charge sheet, well drafted and prepared together with various witness statements, and the charge sheet is read out to you, and then you're asked whether you are going to plead guilty or plead not guilty. If you plead guilty, what will then happen is they will read the facts for you and proceed to sentence you. Take note that once you have pleaded guilty, you cannot appeal against that plea of guilty. The only thing you can appeal upon is when the sentence, whether the sentence was appropriate or not appropriate. If you plead not guilty, the plea of not guilty will be recorded by the magistrate, and the case will be set down for hearing. The hearing is where the prosecution will produce their evidence, call in their witnesses. Before this happens, they ought to provide you with all documents that you need: the charge sheet, the witness statements, the investigation diary, covering report, and in everything else, exhibits, pictures that they would be relying on. In case they do not do that, it is your right to inform the court that you have not been provided with the necessary documents to provide your defense. If the police denied you bail or bond, as soon as you take a plea, put up your hand and tell the magistrate or judge that you would be requesting the court to release you on a reasonable bail or bond term. And the court will consider, taking note of the offense, whether how much the value is, or the severity of the offense, the likelihood of you running away from court and not coming, the likelihood of you interfering with witnesses. And if the court is satisfied that you will not interfere with witnesses, you will attend court when you're called up to, then it will give you bail or bond with reasonable terms. So now we are at the trial. The prosecutor will call all his or her own witnesses who will testify as to whether or not you did what you did. And once the case is closed, the last witness is usually the investigating officer who investigated all this. Once that is done, the prosecution closes their case. And once they've closed their case, you then, the court has to make a decision on whether they have established a case for you to answer, or a case to warrant you being put on your defense. At that point, there are usually submissions. You're given an opportunity to argue before the court and explain to the court why you think the prosecution have not produced their evidence, enough evidence. Remember, the threshold in criminal cases is that they must prove their case beyond all reasonable doubt. So while they're bringing forth their witnesses one after the other, you will be given an opportunity to cross-examine, that is, ask witnesses questions. We'll talk about examinations techniques in a later video, but at this point, the important thing I need you to know is that you would be asking questions to show reasonable doubt in all these witnesses. Lastly, once the court has made its decision, the court could say that, you know what, you have a case to answer. Then it would be your turn to now call in your witnesses, who will then be cross-examined by the prosecutor. But if the court says you don't have a case to answer, it will proceed and acquit you of all the charges. But if you have a case to answer, you will go through your own hearing, call your own witnesses, and then finally the court will make a determination on whether you are guilty or not guilty. Now, assuming the court, you've done that, and the court finds that your evidence is overwhelming and you're not guilty, it will acquit you. But if it finds that you're guilty beyond all reasonable doubt, what will happen? It will set another date for what is called a mitigation address. That is an address that you try to convince the court why it should give you a lesser sentence. After mitigation is done, sentencing will happen and you will be sentenced. But we hope it doesn't get there, because we know that you, the viewers, are law-abiding citizens, and you will make sure that in case you are arrested, you do a very good job at your case. So that is a rough outline of how the criminal process goes on. We will break it down bits and pieces in the next few coming videos. We'll talk about examination techniques, different how to cross-examine, how to ask witnesses, how to deal with the evidence, types of evidences that are produced in subsequent videos. In order to stay updated on our videos, please subscribe to our YouTube channel, click and share this video with whoever may need. Till next time, it's Elvis Abenga, Reflections of a Kenyan Lawyer. God bless you.